Hi, my name is Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to people practically every day who've been involved in car accidents, and one of the most frequent emotions that we see with people who've been involved in car accidents is frustration. And one of the biggest or greatest sources of frustration for our new potential clients is the fact that they're receiving medical bills in their mailbox when they were involved in an accident that wasn't their fault. They just don't think it's fair that they should have to pay any medical bills when something happened to them that they did not cause and that simply was not their fault. Many people ask us, well, why can't the at-fault driver's insurance just immediately start paying my bills right after my accident? And while that might sound like a decent plan, that's just not what the law is in Florida. Under Florida law, everybody who owns a car is responsible for carrying what's called personal injury protection coverage on their automobile insurance plan. Personal injury protection coverage is also called no-fault coverage. And the reason it's called no-fault coverage is because it pays medical bills regardless of fault. So in Florida, when somebody gets involved in a car accident, they first turn to their own insurance company to pay their medical bills. That's what the law has been in Florida since 1973. And so the way that it works is your own insurance company will pay 80% of every medical expense that is reasonable, necessary, and related to your accident up to a grand total of $10,000. And once that amount is exhausted, then you have to turn to your own health insurance or your own pocket to pay any additional medical bills that you have. And so even under the Florida no-fault or PIP system, the person who's receiving the medical treatment still has a small 20% balance left over. And many times that's what people are receiving in their mailbox after they start receiving medical treatment. Well, eventually that 20% is or can be paid by the at-fault driver. However, it doesn't happen automatically. You still have to prove that the at-fault driver was at fault. You still have to prove that your injuries were caused by the accident. Then you have to prove the extent of your injuries. And so most times it's pretty simple to get the other side to pay that 20% of outstanding bills. If you're seriously injured, then the other side will not only pay the 20% of outstanding bills, but will also pay you intangible damages. So that's pain and suffering and inconvenience, and those, we call them human losses, the things that happen to us after an accident that can't easily be quantified. The rub with all of that is, though, if you want the other side of the at-fault driver to pay you anything, what they're going to be looking for in return is a release, a general release signed by you. And that release will say that in exchange for accepting some amount of money, that you promise that you're not going to sue or pursue the at-fault driver or party any further after you take their money. So that's kind of a big deal, and people should be concerned or wary about signing a release unless they're really sure that they're done treating, that they have a good handle on what their medical picture is, and that they really do truly intend to have their case over with. So you're getting bills after the accident. I understand it's a frustrating thing. It's not your fault, but there's still some things that you have to go through in order to wrap things up and make everything turn out in your best interests. So if you have any questions about getting bills after an accident, how to deal with them, how to deal with the whole process, we are happy to answer questions. Just reach out to us. You can call us at 407-254-4901. You can always text us to 407-644-4444, or you can even reach us through the Facebook Messenger app.